Shreya, what is the desirability of UCC?
Yes, ma'am. Ma'am, you see the provisions for Uniform Civil Code has been provided under Article 44 of the Constitution, which is a part of the directive principles of state policy. Ma'am, the desirability or otherwise of UCC is a part of the legislative wisdom, and the state, if it wishes that it wishes to implement UCC, that it can do so. Ma'am, I do not have any particular comment about the desirability of UCC as such.
Can you identify the constitutional challenges that if this comes into act, what are the constitutional challenges that it will face? Can you identify some?
Yes, ma'am. Ma'am, recently the Uttarakhand government has brought forth their Uniform Civil Code, which brings about a uniform set of rules which will govern all the religions regarding marriage and divorce and inheritance. Ma'am, a lawyer has recently challenged that in the Supreme Court, saying that it is against the personal law of the Muslims. So, ma'am, I think that could be a possible challenge to UCC. That since it provides a uniform set of rules, the personal laws of different religions can be said to be jeopardized.
Do we need uniform laws in a country which is so heterogeneous in nature? What is your opinion on that?
Ma'am, the argument generally which is given in favor of UCC is that a person's religion and his religious beliefs can be said to be independent from the secular practice of marriage, divorce, inheritance, and the such, and therefore bringing forth such a law will not impinge on the right of religion which every individual of the country has. So, ma'am, I think that is the opinion that I also possess.
Okay. What do you understand by one nation, one election?
Yes, ma'am. Ma'am, one nation, one election refers to the process of simultaneous election to both the Lok Sabha and the legislative assemblies of the state, so that the elections will be conducted at the same time, and the 5 year period of the Lok Sabha and the legislative assembly will run for the same duration. This is actually done to ensure that the sources are not wasted and it can be an efficient process, and the policy paralysis which is generally imposed because of the model code of conduct before the election, that is reduced. These are some of the arguments which has been given by the government in favor of one nation one election.
Okay. Don't you think it undermines the federal structure, which is one of the basic structure of the constitution?
Ma'am, yes, that is one of the arguments against one nation one election that has been brought forth in the parliament. uh, Ma'am, but I do not have any particular opinion regarding the same.
Do you not see that the national issues will take over the regional issues if this comes into play in the general political scenario of the country?
Ma'am, that is one of the arguments which has been given against it. Ma'am, however, I do not believe that that can be a situation, because although the elections are being conducted at the same time, the parties will contest on the local issues which are prevalent in the local areas, and the people will also vote as per the issues which are relevant to them and which they believe in. They are not bound to vote for the same party at the local level, at the state level, as well as the national level. So they can decide, and the electorate is kind enough and wise enough to decide what issues they want to be considered, and they want to vote according to that.
Okay. Can you tell me the difference between temporary injunction and permanent injunction?
Yes, ma'am. Ma'am, temporary injunction which is granted by way of an application when the suit is ongoing, and it is generally granted for a limited period of time, whereas permanent injunction is generally granted after hearing the parties on merit and after a decree is passed, and it is permanently restraining the person from doing any act which infringes upon the rights of the other party.
Okay. And where in this scheme of injunctions, ad interim injunction stands? What is ad interim injunction?
Yes, ma'am. Ad interim injunction is generally granted in case of temporary injunctions without hearing the other party for a short duration of time. When the court feels that if the notice of the temporary injunction application is given to the other party, a delay will be caused, and that would frustrate the object of the temporary injunction application itself. In that case, the court has the liberty to grant ad interim injunction. It has been provided under Order 39, Rule 3 of the Civil Procedure Code.
Okay. Okay. Over to you, Karan sir.
Shreya, As
Yes,
we
sir.
see, UCC is implemented, right?
Yes, sir.
There is a concept of live-in relationship. There is a
Yes, sir.
mandatory registration of live-in relationship in Uttarakhand, right?
Yes, sir.
So, as per you, what are the negative consequences of regularizing this kind of live-in relationship?
Yes, sir. Sir, I think regularizing living relationships and the process of registering it can be considered to be violation of the right to privacy of an individual because it requires giving personal details about a person to the registering authority, and any objections can also be taken if if the parties in the living relationship are below 21. So it goes against the right of privacy and the right of personal autonomy that every individual has been given under the Constitution.
Basically, you are saying this is a clear-cut violation of fundamental rights of a citizen, right?
So I think it can be a ground for challenge.
So what are the remedies available to a person whose fundamental rights are curtailed by the implementation of UCC in Uttarakhand? If someone wants to live in relationship, but he or she doesn't want to register the same, what are the remedies available with him?
So since the UCC is only applicable to the state of Uttarakhand, if they leave the state, then they might not have to register it.
This is not the legal remedy.
So in
Living in
that
state is
case,
not the legal remedy.
sorry, sir, I
Tomorrow the UCC is
apologize.
implemented in all over India, so the
Yeah.
person leaves India.
So, sorry, sir, I apologize. Sir, if they feel that it's a violation of their fundamental rights, they can approach the High Court under Article 226 for any remedy which the High Court deems fit it can give.
So by what kind of rate?
Mm.
They are going to file a writ or a regular petition.
So in this case, a writ might necessarily not be the proper relief. But the High Court under Article 226 also has the power to grant any other relief apart from the writs which are mentioned therein. So the High Court, whatever relief they deem fit, they can give.
Okay, fine. Shreya, what is the basic difference between kidnapping from India and kidnapping from lawful guardianship and abduction?
Yes, sir. Sir, for kidnapping from India, the person should have been taken beyond the territorial limits of India. So, for kidnapping from lawful guardianship, which is provided under Section 361 of the Indian Penal Code, if a person is below 18 years of age, in case of a male, and below six, sorry, sir, in case of a female, and below 16 years of age in case of a male, and he has been enticed or taken away from the lawful keeping of the guardian, then, so that will be kidnapping from lawful guardianship, and the guardian's consent should not have been given. But abduction, on the other hand, can be applicable to any person. There's no age restriction there. And if the person has been deceitfully taken from one place to another place, then the offense of abduction can be there. However, sir, abduction per se is not an offense under the scheme of Indian Penal Code. It has to be accompanied with an intention to commit any other offense, such as murder or forcefully marry a woman, as has been provided under IPC.
So, as of age limit, right? Is there any difference between kidnapping from India and abduction?
No, sir. So the IPC does not provide any restrictions for age for kidnapping from India or abduction.
Okay, fine. Last question from my side. What is
Yes,
the
sir.
difference between regular bail and interim bail? And at what stage the same can be filed?
So regular bail applications, a person can approach the Court of Magistrate under Section 437 or the Court of Sessions or the High Court under Section 439 when he has been arrested. So interim bail is generally given in cases of anticipatory bail when a person has approached the Court of Sessions or High Court under Section 438, and the court decides that without hearing the complete application or without giving the other party an opportunity of being heard, the court can give them an interim bail for a shorter duration till the next date of hearing is fixed. And for interim bail, which is given an anticipatory bail, this is before the person has been arrested when there is just an apprehension of arrest, whereas regular bail is after the person has been arrested.
Basically, you are saying anticipatory bail, sorry, interim bail is a part and parcel of anticipatory bail, right?
Yes, sir.
Okay. Over to Mohit, sir. Please, sir.
Shreya, if we suppose there is a criminal case under Section 498A,
Yes, sir.
the accused is not appearing for the court, ultimately was declared PO. And after some time, he appears, the trial concludes, the accused stands acquitted. What
Yes, sir.
about the person who was declared PO by the court? Is there
Yes, sir.
any liability of that person or not? He will go
Yes, sir.
scot free because no case is made out against him. The
Yes,
court say
sir.
no case is made out. There is no evidence, so he is acquitted.
Yes, sir. Sir, even though he is acquitted for the main offense, although he was declared a proclaimed person or a proclaimed offender and is not appeared, he can still be held liable under Section 174 capital A of the Indian Penal Code because non-appearance after the proclamation has been given is an independent offense apart from the substantive offense.
Yes, this is very interesting provision because he is acquitted in the main case.
Yes, sir.
But since he was a PO,
Yes, sir.
he wasted the precious time of the court. Why this is new provision?
Yes, sir.
Otherwise, did they see they don't appear in the court till either the witness won over, or they are bribed, or they sit
Yes, sir.
down. They don't. They depose against them. They will not appear.
Yes, sir.
So that's why they this very good provision. The
Yes, sir.
accused and acquitted in the main case he is acquitted, but because since he was a PO, he is convicted in this without any trial. After trial,
Yes, sir.
is acquitted, but
Yes, sir.
without trial, he is sentenced.
Yes, sir.
This is very marvelous provision.
Yes, sir.
So, can you tell us the difference between substantive law and the adjective law? What?
Yes, sir. So, substantive law deals with the rights of the parties, whereas procedural law merely provides the mechanism through which such rights can be enforced. It provides the remedies and the mechanism so that the rights are enforced in a proper manner.
Okay. So, what is the significance of TIP in criminal case? Test identification pit when it is
Yes,
held,
sir.
and
Yes,
what
sir.
is the evidentiary value? What are the precautions to be taken while holding? Because it is the magistrates only who
Yes, sir.
record this.
Yes, sir.
The session
Sir.
is on.
Yes, sir.
So you tell us
Yes,
why
sir.
it is required, why TIP is required, and how is it
Yes, sir.
conducted, where it is conducted, what
Yes, sir.
precautions to be taken
Yes, sir.
at the time of recording it, and at the evidentiary value. All the three in one question.
Okay, sir. So test identification period, the provision has been given under Section 9 of the Evidence Act.
Okay.
It is conducted during the stage of investigation so as to assure the investigating agency that they're proceeding in the right direction, and also so that the identification which is done by a person, by a witness, it can be used as a corroborating statement when the witness actually identifies the accused in trial. So it does not have an independent it's not a substantive evidence, and its only evidentiary value is for corroborating the statement of the witness which is given in court when he identifies. Search should not be conducted by the police because then it will be hit by Section 162 of the CRPC. It should be conducted by a magistrate. Generally, a judicial magistrate or an executive magistrate can also conduct it. And so the precautions which has to be taken is generally the person who has to be identified and other similar physique persons should be in the ratio of 1:9, as has been given under some police manuals. And it should be ensured that the witness who has to identify him has not seen him before, and his photo should not be shown to the witness, or his photo should not be in media, so that there's no other prior knowledge of the witness, the prior knowledge of the witness. Um, Yes, sir. These are some of the, and their faces should not be covered. And yes, sir. This is the precaution
So
I can think of.
okay. Next, where the immovable properties spread over different parts of the area,
Yes, sir.
which court shall have the jurisdiction to deal with it?
Yes, sir. Sir, as per Section 17 of the Civil Procedure Code, any court within whose jurisdiction any part of the property is falling can deal with it, provided that the pecuniary value of the subject matter is also within its jurisdiction.
Okay. Next would be doctrine of limitation,
Yes.
prescription, and laches. Explain all the three.
Yes, sir. So, doctrine of limitation is generally based on public policy has been given under the Limitation Act. So, if a prescribed period is given, then the parties should vindicate their rights within that period, and after that, their remedies would be extinguished. So, doctrine of prescription is given under Section 25 and 27 of the Limitation Act, which says that if an easementary rights has been used for a particular period of time, then the parties can gain that right. Also, under Section 27 of the Limitation Act, cert has been provided, which provides for adverse possession and perfecting title by adverse possession. So, after 12 years, if all the conditions of adverse possession are satisfied, the person can rightfully become the owner, in exclusion of the actual owner. So, whereas doctrine of laches only provides that while filing a suit, if there is a certain inordinate delay, although it is within the limitation period, but it is inordinate delay, then the courts will not generally look at it favorably and will frown upon it.
Okay. Next one is there any time limit for the judicial officer to pronounce judgment after conclusion of the trial, after hearing final arguments? Is the time limit? Maybe 2 days, maybe 3 years, or maybe 6 months. Is there under law, is there any time limit?
Yes, sir.
Or he can decide within 2 days or any time it is wish?
Sir, under the Civil Procedure Code, a time limit has been given that the judgment should be pronounced within as soon as possible, otherwise within 30 days, or if it is not possible, then for reasons to be recorded in writing within 60 days from the conclusion of the hearing. So, but for criminal case under the CRPC, so there was no time limit given. But the Bharatiya Nyaya Surakshit Sanhita provides for a time limit for pronouncing of judgments, which is 30 days from the conclusion of the trial.
Shreya, very good.
Thank you, sir.
Good knowledge of law, very good on fairly good knowledge of law.
Thank you, sir.
Well explained, the answer well explained, to
Thank
the
you, sir.
point. Keep it up. All the
Thank you,
best.
sir. Thank you, sir.
Shreya, you are very good. I just
Thank you,
think
ma'am.
there is one scope for improvement. Whenever an
Yes, ma'am.
opinion-based question is asked, restrict yourself from saying that I don't have any opinion on it. Maybe you can form a neutralized opinion. Say something very neutral. I understand the limitations that you have sitting there. You
Yes,
cannot take
ma'am.
a side which is against the establishment or
Yes,
anything like that. You don't want to say anything offensive. But
yes,
still,
ma'am.
rather than saying that, I don't have any opinion, because I'm sure you're very well aware of everything that is going around. And
Yes,
since
ma'am.
you are going to become a judge, you need to have some opinion. Maybe you need to have a rational and reasoned opinion. So whatever you are saying, you might also as well think of a reason that, okay, if they ask why are you saying this, you might also say, sir, because of these provisions. Okay.
Yes, ma'am. Yes, ma'am.
श्रेया, एवरीथिंग इज वेरी गुड, बट
Thank
मेक
you,
श्योर
sir.
एक बात आप जरूर समझें, देर इज नो रिक्वायरमेंट टू गिव आंसर टू ईच एंड एवरी क्वेश्चन।
Yes, sir. Yes,
अब
sir.
यूसीसी का मैंने आपसे क्वेश्चन पूछा, आप उसमें कंफ्यूज होते चले गए,
Yes, sir.
टिक कर दीजिए। सॉरी
Yes.
सर, आई एम नॉट एबल टू रिकॉल राइट नाउ द रेलेवेंट प्रोविजन, राइट। गेस मत करें, और वो एक जो ब्लंडर होता है, ब्लंडर मिस्टेक ना करें, राइट। एंड
ठीक है, सर.
लास्ट में अभी आपने बोला भारतीय न्याय सुरक्षा संहिता, दिस इज नॉट
Bha-
भारतीय न्याय, भारतीय नागरिक सुरक्षा संहिता।
Yes, sir. Yes, sir.
ये एक बहुत मेजर मिस्टेक है आपकी। वहाँ साइकोलॉजिस्ट भी बैठे होते हैं पैनल में नंबर ऑफ टाइम्स, तो
Yes,
वो
sir.
यही चीज ऑब्जर्व कर रहे होते हैं, राइट।
Yes, sir.
जरूरी नहीं है हर क्वेश्चन का आंसर दो, कोई प्रॉब्लम नहीं है। रेस्ट यू
ठीक
आर
है,
गुड,
सर.
हो, कॉन्फिडेंस बहुत अच्छा है, सेटल्ड हो, लॉ की नॉलेज बहुत अच्छी है आपकी,
Thank
राइट।
you, sir.
तो
Thank you, sir.
बेस्ट ऑफ लक,
सर,
होप फॉर द
सर, एक
बेस्ट।
क्वेश्चन था.
जी
सर, उसका आंसर क्या होगा कि अगर पार्टीज लिव इन रिलेशनशिप रजिस्टर नहीं करना चाहते तो वो क्या करेंगे?
फंडामेंटल राइट्स हाईकोर्ट में आप अप्रोच करेंगे।
अच्छा.
हाँ, उसको
ठीक
चैलेंज करने का तो एक ही मोड है ना आपके पास।
ठीक है, सर.
ओके, थैंक यू।
ठीक है, सर. थैंक यू, सर. थैंक यू, मैम.